Imagine a couple who exchange rings in a sincere religious ceremony. They live together for 18 years, raise 4 children, and build a life intertwined. But when the relationship eventually breaks down and one of them files to divide their assets, the judge delivers a shocking ruling. They aren't allowed to get a divorce because in the eyes of the law, their marriage never existed. This exact scenario plays out in real courtrooms, most notably in the landmark case of El Gamal versus Al Maktoum. The dispute involved a member of the Dubai royal family and a woman who claimed they were married. She argued that a secret Islamic ceremony had taken place in a London flat, but the judge found that there was absolutely no written evidence of the event. Because the couple completely bypassed English legal formalities, the court ruled that the event was a non-qualifying ceremony. This created what English law calls a non-marriage. The union was so procedurally flawed that it couldn't even be formally annulled. The relationship was completely invisible to family law. It reveals a harsh truth. A beautiful, emotionally sincere ceremony offers zero financial or legal protection for either partner unless they strictly follow the state's bureaucratic rulebook. That rulebook begins with what are known as the civil preliminaries. Before any vows can be legally recognized, the state has to be formally notified of the intent to marry. Couples are required to give an official notice of marriage in person at the specific district registry office where they live. It's a mundane bureaucratic step, but it is absolutely vital. This diagram illustrates the next requirement, a mandatory waiting period. After notice is given, a couple must wait 28 full days before a ceremony can take place, acting as a forced legal cooling-off and investigation window. Once that window closes, the law dictates exactly where the vows can be exchanged. A legal marriage must occur at approved premises, a registered religious building, or, thanks to recent rule changes, a permitted outdoor location. These location rules are enforced without exception. When Prince Charles and Camilla Parker Bowles planned their 2005 wedding, they actually had to move the ceremony out of Windsor Castle because the castle lacked the required civil license. Even in an approved room like this, the ceremony is only valid if specific people are present. You must have 2 witnesses, and the ceremony must be conducted by a legally authorized celebrant or registrar. These tight restrictions on locations and personnel ensure that the marriage is a publicly accountable, legally monitored event. But even if you do all of that perfectly, the spoken vows themselves are legally meaningless until you complete one final step, post-ceremony registration. Immediately following the ceremony, the couple must physically sign the marriage register. Looking at the required fields on this register, the exact elements needed to lock the contract are clear. You need the signatures of both parties, the 2 witnesses, and the superintendent registrar. Now, if a couple goes through this entire process, but a fatal legal flaw exists in the background, for instance, if one of them is already married to someone else, or they are closely related by blood, the state classifies it as a void marriage. A void marriage is different from the non-marriage we discussed earlier. A void marriage formally existed on paper and must be legally annulled by a court. A non-marriage never existed in the first place because the couple completely bypassed the paperwork. Ultimately, the physical stroke of a pen on the state's official ledger is the actual mechanism that transforms a romantic relationship into a legally protected union. Family law is modernizing to reflect how people actually live. Today, recognized relationships have expanded, including the introduction of civil partnerships for all couples. Despite these modernizations, the foundational rule has not changed. The requirement for state recognition remains absolute. This brings us to one of the most widespread and dangerous societal myths today, the idea of the common law spouse. This chart shows exactly why that myth is dangerous. Cohabiting couples make up 18% of families, yet have no automatic legal status. If the relationship ends, the court cannot simply transfer property to achieve fairness, a power heavily relied on during divorce. Ignoring the rigid bureaucracy of marriage formation leaves individuals completely exposed. If the relationship ends or a partner dies, the surviving partner has no automatic inheritance rights. In family law, love might be the reason 2 people come together. But it is meticulous adherence to civil formalities, and that decisive stroke of a pen, that actually protects them.